Senate Judiciary Committee meeting, criminal law. And for the record, this is January 20th, 2021. And we will be having a hearing on Senate File 89 today. Let the record show that we do have quorum. Before I get into Senate File 89, I did want to talk just to review a note that we gave our committee administrator, Angela Cook, gave out to you all. And I just wanted to review it just quickly for the benefit of public knowledge for those that might be listening. We're trying to, of course, have every meeting run as smoothly as possible. And it's good to review some of the kind of the rules on how we run our committee. We sent, as I said, a notice to you. Unfortunately, the Zoom meetings have kind of complicated a few of our rules a little bit, but I did want to just review them. I really want to strongly encourage our members, if you have substantive amendments, if you could advance them to our committee administrator as soon as you can, preferably a day before, so they could be included in your packets and posted publicly. Now, this is not a 24-hour rule. I don't believe in those things. I think I despise 24-hour rules for amendments. I think they ruin spontaneity of discussions, and I honestly believe they hinder problem solving. But there are going to be amendments that are going to, well, be created as a result of our discussions. And if you have a substantive amendment that's in that manner, we will require a pause in the committee in order to get it in written form. That allows our CA to receive and post the amendment to the committee's members as well as the public. So just keep that in mind as we're going forward. If you have something substantive that's going to be discussed anyway, it would really help the process if we had them in advance. Also, having said that, if we have oral amendments, and we sometimes do improve bills, well, not sometimes, we have, the judiciary has a long-standing reputation of improving bills, and at times we have to offer oral amendments as we go forward. I know that we're probably a little different than most committees in that regard. Oral amendments can be challenging. They often can be time consuming. And if it does get into a serious time consumption, we would have to lay that bill over in order to accommodate an oral amendment that might be substantive. If it's something, a word change, a spelling error, or a sentence restructure, I think we can probably handle that. When it comes to voting, voice votes will be taken as normal. If there's a call for a division, members will be asked to show hands on the screen like this, in favor or opposed. And that way, it's no different than if the public was viewing us in a person-to-person meeting. They would be able to see our votes or hear our votes cast as a voice vote. And of course, roll call votes will continue as usual. I just wanted to make sure everyone understood that, and more importantly, for the public to understand that the Zoom meetings have provided a little more challenge to our structure. But having said that, I'm going to pass the gavel to our Vice Chair, Senator Mark Johnson, for the remainder of our committee hearing.
Thank you, Senator Limmer. Senator Limmer, do you need some time to set up for your bill presentation?
No.
All right. Why don't you proceed then in with your bill, please?
Thank you, Mr. Chairman. I'd like our members to focus on Senate File number 89. It's in your packets. This is to clarify the application of a criminal penalty for a violation of Minnesota Statute Chapter 12. Chapter 12 is the reference that gives the executive branch or the governor the ability to call for a peacetime executive order. And that in turn moves in the direction of how do you enforce those executive orders. And there has been discussion and examples of executive orders this past year that have triggered and have, well, not only, I guess it is a triggering of a gross misdemeanor, although our state statutes limit that penalty to a misdemeanor unless it's prescribed by law. And in order to be prescribed by law, it means the legislature has to pass that particular penalty. The events of COVID-19 pandemic has raised concerns about the executive branch interpretation of laws governing peacetime emergency powers and enforcement actions. Under Minnesota Statute 609.095, the legislature has the exclusive authority to define crimes and the range of sentences and punishments for their violation. In Chapter 12, a willful violation and associated rules and orders is clearly and specifically a misdemeanor under Section 12.45 unless a different penalty or punishment is specifically prescribed. Prescribed meaning passed by the legislature. A violation of an emergency order is a misdemeanor unless the statute provides a different penalty. I believe in the last year, the governor's office has had a unique and different interpretation of Statute 1245. As an example, Emergency Executive Order 20-33. It was signed and filed on April 8th of last year. It provides that it's a misdemeanor under Minnesota statutes for a worker to willfully violate the order of an EO, but an enhanced gross misdemeanor for a business owner, manager, or supervisor to require or encourage an employee to violate the order. Now, this is just one example of a few executive orders that have made reference to gross misdemeanors. And it's predicated on a theory that Minnesota Statute 1245 authorizes the governor to prescribe a different penalty from that misdemeanor reference. I believe the scope of the governor's authority under Section 1245 is incorrect and inconsistent with legislative intent. Quite honestly, this is really a discussion of who has the authority to write statute with the effect of law and the effect of punishment. Clearly, that is the role of the legislature, and once passed, the governor, whoever that might be, has the ability to consider and sign that provision into law. I don't believe that an executive order authorizes a governor to impose unilaterally a gross misdemeanor. This could become alarming. I don't want to put all the focus on this particular executive position or this governor. I think we need to think of any governor as they're interpreting the law and their authority under Chapter 12. I believe if we do not assert legislative authority, there could be no limitation of the severity of a punishment any governor could impose during an executive order status. And that's why I brought this bill forward. And Mr. Chairman, that would conclude my introductory remarks right now. I do believe that we have a testifier waiting to give testimony, Mr. Matt Elling.
Well, thank you, Mr. Chair. We'll turn now to your testifier. Mr. Elling?
Thank you, Mr. Chairman. Are you able to hear me okay?
Wonderfully.
Okay, thank you. My name is Matt Ealing, and I'm a resident of St. Paul, Minnesota. I'm here today in my capacity as a private citizen, one who's been involved for many years as a volunteer on various initiatives related to examining governmental power and conduct. If you wound the clock back 16 years, at that time you'd find me debating the U.S. Attorney for Minnesota about provisions of the USA Patriot Act, a different administration run by a different party, and in the context of a different national emergency. And I raise this point to highlight the fact that I believe examining issues of governmental power is important to do consistently, and I've always tried to do it in a way that's really irrespective of politics. Without a doubt, the COVID-19 pandemic has presented our nation and this state with a serious public health crisis. And governing during such a crisis is a difficult task. And sometimes the emergency actions taken by the executive, they press against the prerogatives of the other branches of government, and they cause debates over the proper scope and organization of governmental authorities. And we've certainly seen these debates before. At a national level, we saw this dynamic play out after 9/11, another serious emergency faced by our country. People might recall that in the aftermath of the 9/11 attack, the actions of the executive branch at that time and the legal interpretations that underpinned those actions, they spurred a number of court challenges as well as statutory changes. The Bush administration, for instance, put forth broad legal theories about executive detention until the U.S. Supreme Court ruled otherwise in the Hamdi case. After that, the Obama administration claimed the authority to order telecom companies to produce call records of essentially every telephone call made in the United States on the legal theory that every call in America was relevant to an ongoing foreign intelligence investigation. And that practice was ultimately curtailed by Congress. So historically, we've seen a process occur whereby the other branches of government have looked at how the executive has used powers granted during an emergency and then has acted to narrow or clarify those powers when there's a dispute. And I'd suggest to you that this is a necessary and proper function in a system based on separation of powers principles. So the bill before you today deals with an interpretive dispute, as Senator Limmer mentioned, and a dispute that has arisen out of our current pandemic crisis relating to how the executive has interpreted the State Emergency Powers Statute, Chapter 12. Senator Limmer has given you good background about what Chapter 12 does. It does include the ability for the governor to grant certain issues and orders, and it has a provision setting out penalties for violations of those orders. Minnesota Statutes Chapter 12.45 states that unless a different penalty is specifically prescribed, a person who willfully violates an executive order issued under Chapter 12 is guilty of a misdemeanor. And those misdemeanor penalties have been used in several of the executive orders issued during the COVID pandemic. And where the disputes have arisen, as Senator Limmer has mentioned, has been in regard to some orders that have established enhanced penalties, gross misdemeanor penalties. Another example is Executive Order 2074, an order that provided reopening guidance to businesses and set out certain gross misdemeanor penalties for violating that guidance.
Mr. Erling,
oh, yes.
We've got a couple of questions. Could we pause for 1 second here?
Yes.
Senator Latz, you have your hand up.
Thank you, Mr. Chairman. I can wait until after Mr. Ealing is done testifying.
All right. Thank you, Senator. Senator Anderson, you also have your hand up.
I too can wait till after Mr. Ealing has testified. Thank you.
All right. Thank you. Sorry about that, Mr. Ealing. Why don't you continue?
Thank you, Mr. Chairman. So this issue over disputes regarding the misdemeanor penalty or gross misdemeanor penalty, or what's the trigger for penalties under Chapter 12, it's been raised in lawsuits, including one that's pending currently in federal court, the Northland Baptist Church litigation. In that case, the plaintiffs argued that the governor's assignment of penalties that exceeded a misdemeanor, that violated the separation of powers by invading a purely legislative function. And in reply, the government's responsive brief set out the theory that the misdemeanor penalty in Chapter 12 is only a default penalty, and that the statute did not limit the governor's ability to prescribe a different penalty or punishment. The reply brief did not suggest really the existence of any cap or any limit on additional penalties that could be imposed. The brief simply said that so long as they were specifically prescribed by the governor, then those penalties would be legal, according to the government's theory. And that interpretation then really raises the question of whether there is a functional limit to the governor's power to impose penalties during a Chapter 12 emergency. And in the context of some of the executive orders that have been issued, it's worth asking, can the executive alone determine that a felony penalty rather than a misdemeanor be used to penalize, say, in-home gatherings that exceed 10 people? Or is there any limit to civil monetary penalties that can be assessed for violations of business reopening guidance set out by executive order? So ultimately, if that's not what the legislature intended, then the legislature can act to clarify that Chapter 12 only makes reference to penalties enacted by the legislature, and it's not a license for the executive branch to create its own penalties. And that's what the bill before you today accomplishes. And to close, I think it's worth making such clarifications, really, since legal theories established during an emergency, they don't automatically disappear when the emergency is over. They can persist, they can affect how future executives address emergency situations, and even shape interpretations of non-emergency law. So to close, Mr. Chairman, this session, the legislature will have an important role to play in addressing the ongoing COVID-19 pandemic. I wish the legislature and the governor luck in addressing that ongoing challenge. But I think it's equally important to address the structural issues that flow from the state's experience with Chapter 12. And this bill, I think, is part of a necessary review. So thank you for your time, and I'm happy to stand for questions.
Thank you very much, Mr. Elling. Senator Latz, let's go back to you then for your question.
Thank you, Mr. Chairman. And I have a question or two for the Senator Limmer. But before I say that, I just want to note this language in 12.45 is precisely the same as the language when this statute was originally passed in 1951. So it's at least been a long-standing and never before questioned provision in our statutes. So I guess one question I have for Senator Limmer in his opening remarks, he stated that when he read this provision, and then he said, meaning that, as if to state it as an established principle of law, meaning that the penalty or punishment had to have been specifically prescribed by law or statute. And I was wondering if Senator Limmer had any citation he could give for that conclusion, other than his own interpretation or those of others presently evaluating in this conversation.
Senator Limmer.
Thank you, Mr. Chairman. Senator Latz, I do not have a citation. However, I would like to ask Mr. Backus if he has an interpretation or a knowledge of what prescribed means.
Mr. Backus, would you take yourself off mute and answer that?
Thank you, Mr. Chair and members. I don't know that I don't have a definitive answer to this issue. I think it's a matter essentially of statutory construction. The statute doesn't say specifically statute. I think that's how a lot of people have interpreted it, but obviously the governor's office has interpreted differently, so it's somewhat ambiguous.
Mr. Chairman? Well, Mr. Chairman,
Senator Limmer.
If Senator Backus's reference is correct, now would be the time to put a definition to the word prescribed. And I believe prescribed should mean, it does refer to a previous action. I would assume that the previous action can only be made by a legislature.
Mr. Chairman?
Senator Latz.
So to follow up on that, there have been, to my knowledge, 2 cases in which this language has been interpreted, at least specifically is relating to this governor's executive orders in the pandemic. One of which was in the Supreme Court, in which the Chief Justice articulated two different potential interpretations of this language, including that which is made by the governor's office or also by the Attorney General's office in their briefing. And the other was by a Stearns County District Court in the recent O'Shady's enforcement action there. The Stearns County District Court judge concluded that prescribed, without anything further, did give the governor's office the authority to determine the level of the penalty. So I think really, and the Supreme Court Chief Justice in her decision didn't find it necessary to choose between two alternative interpretations, because she was able to address the point they needed to confront without going there. But she did admit or did acknowledge that it was at least one interpretation. And I think the language is ambiguous in the statute. I think it is open to interpretation, and I don't fault the governor's office for attempting to impose greater penalties on businesses that would encourage or even require employees to violate an executive order on penalty of losing their jobs and come in to work in a business that is supposed to be closed, or to work in a business that is not abiding by the population requirements, 50% or 25% of their capacity, for example, because that I think to me is deserves more than simply a misdemeanor penalty threat. But I think the question before us today really is not one of, do we think that the policy position that the governor's office took with regard to the level of penalty that's appropriate was the correct position for them to take. I think the question is more one of, what is the appropriate role of the legislative branch vis-a-vis the executive branch? And this gets to the separation of powers question. And I, like Senator Limmer, am quite concerned about the prospect of appearing to have delegated to another branch of government, or well, to the executive branch of government anyway, the ability to make decisions about the criminal consequences of orders coming from the executive branch. So without disagreeing with the terms of the executive orders themselves, I do believe that it would be wise for us to add in the clarifying language that's proposed in Section 2 of this bill and make that a part of statute. And that would continue to clarify and reserve unto the legislature the sole ability to make those determinations about what the maximum criminal penalties would be for any particular conduct. Should we have a desire to make any changes in any particular circumstances, the legislature does have the ability, exercised or not, to hold hearings and pass laws, statutes that would modify those things. So personally, I think we have had 11 months to have hearings, consider proposals, and pass laws to make adjustments or changes in executive orders that we dislike. Not quite 11 months, 10 months since the first executive orders came out, which did include penalty provisions in them. And this committee has not seen fit to hold any hearings on any of those issues. That's why I'm a bit concerned. That's why one reason I'm very concerned about some of the language that's in Section 1, the legislative findings that are part of this bill. And so I actually have a question for Senator Limmer in that regard. Historically, whether this committee was chaired by Democrats or Republicans, in the Senate, anyway, we have not favored provisions in substantive bills that included legislative findings or declarations of policy, unless in very unique circumstances the bill was so broad in scope and we anticipated that courts would need to have some guidance as they are interpreting potentially voluminous language within a statute. For example, the workers' compensation statute, I believe, has a sort of a forward, if you will, along these lines. The Human Rights Act does. But many bills have come before us, most of which have been initiated in the other body, which contain language purporting to establish legislative findings. And I will confess, I don't remember any of them that appear to have been as broad-based or as in your face to any particular branch of government or particular elected official as the one we have before us today. But I'm wondering if Senator Limmer can explain, or maybe he'll simply join me in expressing his and my longstanding opposition to provisions like Section 1, and would join me in a motion to delete that section.
Senator Limmer, I think that was the question.
Yeah, I understood it. And I had to laugh because Senator Latz and I have had numerous discussions over legislative findings that we discover in legislation, and we usually take a broad axe to them immediately. And so I anticipated Senator Latz would be bringing this up. The reason I put it into the bill is that in a way, I don't think we've ever, as you may have referenced earlier, Senator Latz, since 1951, when Chapter 12 was it initiated at that time, we haven't had too many executive orders since that time. And the pandemic that we're now experiencing is rather unique. Some people might call it historic, and it's tragic in many ways. Because of the uniqueness and the stepping away from the reference in statute 609.095, which says the legislature has the exclusive authority to define crimes and punishments. I thought that was the unique historic event that triggered us to respond and to clarify. And that's why I added the legislative findings and purpose. Mr. Chairman, I have a question for Senator Latz.
Senator Latz, we willing to take question?
Of course, Mr. Chairman.
All right.
Question I had, Senator Latz, if we removed Section 1 from the bill, would you support the bill in its amended fashion?
Mr. Chairman, Senator Limmer, yes.
All right. Would you want to make that an amendment at this time?
Mr. Chairman, I move to delete Section 1 of the bill.
All right. Senator Latz makes a motion to delete Section 1 of the bill.
And Mr. Chairman?
Yes, Senator Latz.
Before you cast a vote, I agree with Senator Latz in the broad context that I don't think legislative findings are necessarily to be put in bills unless they have very unusual and unique circumstances. I've made my point by including it and raising it as a discussion item, and I would be satisfied with the remainder of the bill. I would find that Senator Latz's amendment would be considered friendly at this time.
Thank you, Senator Limmer. Senator Latz's amendment then is to just simply delete Section 1 of the bill. Is everyone clear? We would be retaining Section 2 of the bill. I see some head shaking. So with that, all those in favor of the motion, say aye.
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 All opposed, same sign. Ayes have it. The motion passes.
I didn't get to say aye in time in favor of it.
Okay. Well, the motion passes. So section 2 remains, section 1 has been removed. So do we want to take a moment here to make sure that that gets posted in time? I know there's some procedural issues there too, making sure that that gets out to the public. Senator Limmer?
Well, Mr. Chairman, it was an oral amendment. It was passed. The bill is now in an amended form, and you now are under the consideration of the remaining bill.
Okay.
And I see that there is a hand up, so there may be a little more discussion prior to the final vote. I find no reason to pause the committee action. It would be the same as we would do last year prior to a Zoom meeting.
Sure. Well, that sounds good. I'm still trying to get used to the differences here with Zoom, so appreciate the guidance there. Senator Bigham, you have your hand up and you're on mute.
Thank you, Mr. Chair. Mr. Chair, did Senator Anderson still have a question? Because his hand was raised before
Sure.
mine.
Thank you.
Mr.
Senator
Chair,
Anderson.
the question was basically done away with when section 1 was canceled.
Okay. Senator Bigham.
Thank you, Mr. Chair. And I don't disagree with the intent of or the language of the bill. I do think, though, that on our inauguration day today, whether your person won or lost, it's a day of unity. It's a day of celebrating our democracy. And this kind of feels like a little bit of same old with divisiveness. And so I hope this isn't a custom and isn't going to continue through the rest of the session so that we can have progress and be part of a team. This is the legislature's job. This is the legislature's job to do this. And the executive order that protects workers and protects customers, the Senate should have had hearings on this 10 months ago. The whole time the governor has wanted a partner, has wanted us to do our job. And the Senate hasn't. It hasn't had hearings where bills were proposed, where witnesses were able to testify, amendments and votes were able to be taken. It hasn't happened. The Senate failed to do their job and to be a partner. And so I'm going to support the bill because I came up here to do my job, not just poke at somebody and be an obstructionist. Minnesotans expect better. Minnesotans deserve better. Where is the plan? Where is the plan from the Senate? I intend on supporting the bill.
Chairman?
Senator Limmer.
Mr. Chairman, Senator Bigham, just as a reminder, I'm getting a little feedback on my end. Hope we can continue. Just a reminder, during the time of the interim, the Judiciary Committee was not constituted as a committee. We could not have made committee action during that time, number one. Number two, it is correct, Senator Bigham, we have inauguration day today. Quite honestly, the Senate is doing their job, even on inauguration day. We're trying to we scheduled only one bill, so those of you who might want to witness inauguration on television and all, you'll have time to do that, I hope. But nevertheless, we were trying to be respectful of that, but at least address this issue. In what, the fifth or sixth time, maybe not even fifth time that we've met as a committee. We're just beginning to catch up to some of the early bills that are now on our roster. And so we are doing our job, Senator Bigham. And as we begin to look over the roster of bills, we're developing our plan.
Senator Bingham, to that point.
Yes, exactly to that point. Mr. Chair and Mr. Chair, when the governor calls us back in for a special session, which he did 8 times, we can recess the Senate and committees can commence because we decide when we end the session. So no, the Senate hasn't done their job because we haven't had committee hearings where legislation can be proposed, votes taken, amendments offered, a plan presented to the other body for agreement or dissent, going to a conference committee, and then putting that final product on the governor's desk for a veto or a signature. So I'm glad that people are jumping on the let's get a plan train. And I hope that we all continue to ride this train to be that partner that the governor has expected, Mr. Chair.
Mr. Chairman.
Senator Limmer.
Mr. Chairman, I'd like to remind the committee that the order of our business right now is Senate File number 89. It's a very narrow aspect of our discussion. Broader comments about the character of the Senate or this committee, I would consider out of order, but that's your call, Mr. Chairman. And we will certainly have a very long session until May to discuss all of the concerns that Senator Bingham may have.
Thank you, Mr. Chair. Point well taken. I will go to Senator Kiffmeyer. She has her hand raised.
Thank you, Mr. Chair. In all due respect, I really thought that the other Senator Bingham was going to talk about today, Inauguration Day, and working together, and how wonderful it was that Senator Limmer and Senator Latz were working together on this bill. They have longstanding history of these kinds of languages coming before them, and they understand the conversation and the nature of their purpose. And in a very collegial way, it was amended and deleted out. And I thought that was, where are you going to go with this? Isn't this a good thing that, we have this kind of conversation and working together right now? And instead, we go into criticism and attacks that I consider divisive. I find that kind of conversation out of order in our subject of Senate File 89 right now. But I just want to say, I hope that we can stay focused on the bills that we have before us, discussing the actual bills and bill language, and each one of us doing that. But these other kinds of comments are divisive. And I think on Inauguration Day, and congratulations to all of you, your candidate won. And we congratulate you on that and respect that. We are doing our business here, and you may disagree, but disagreeing doesn't mean being hypercritical in a situation like today. Thank you, Mr. Chair.
Thank you, Senator Kiffmeyer. And I think with that, let's get our focus back on, if you have your hands raised and it's not regarding Senate File 89, we can save that debate if you'd like. Senator Matthews, to the bill.
Yes, thank you, Mr. Chair. I am a strong supporter of Senate File 89 for the main reason of it is a good government bill. It gets us back to a constitutional form of governing. And it also passes the shoe on the other foot test, as I like to call it. We are in a situation now where these orders and emergency powers have been the cause of a partisan divide across our state, not just the legislature, but I hear it all over my district in many different ways. And were the shoe on the other foot, if the parties were reversed, it's not unfathomable to think that the positions of the political parties would be reversed themselves. Now, I would join the other side if there was a Republican governor that decided that he could make an executive order and he could come alongside and decide that he had a new interpretation of what was in statute than what had been the standard and commonly understood interpretation from the statute's formation in 1951, and decide that his secondary new interpretation was the one that was valid and should be enacted, and set whatever penalty he chose. I would have the same opposition to a governor of my own party deciding to do that, as I've had opposition of the current governor making those choices. So I often think of bills as we've had many debates and discussions over these issues, over many issues related to COVID-19 response and the things that we have done in our special sessions all summer long. Is what would I do were the shoe on the other foot? Would I still support this position if the sides were reversed? And I think that if you can answer yes to that question, it's likely a good policy bill that should be enacted. And if you can't say yes to that, then maybe you have to look as to whether or not your goal is just a hyper-partisan manner. This bill is clearly one that I can say yes to. I would support this if the sides were as they are today, and I would support this if the sides were reversed and a governor of a different party was making some of these kinds of determinations. And it's not the legislator's role to wield in or try to rein in a governor that goes out of bounds of the constitutional rails. It's the governor's job to keep himself within the constitutional guardrails as well. So this extra guardrail, like growing up on a farm, if you had your goats or your sheep or your cows that jumped the fence, you had to go along and add an extra rung of the fence a little higher to try to keep them in the place where they need to be. And this bill today is that extra rung on the fence to make sure that this governor and all future governors, regardless of party, stay within their constitutional bounds. So I am glad to see the bipartisan support for this bill, and I thank Senator Limmer for bringing it forward.
Thank you, Senator Matthews. Senator Latz, you also have your hand up. Question?
Yes, thank you, Mr. Chairman. A couple of thoughts. One is just in response to what Senator Matthews had to say. I'm not sure it's fair to conclude that the governor this year gave a new interpretation to an old statute. I just don't think there had ever been any occasion in the last 70 years for there to be any interpretation of that particular clause. I'm not aware of any executive orders. Actually, I'm not aware of any similar situation where we've had a series of executive orders of this nature because of the unique aspects of dealing with the pandemic, as opposed to, say, an emergency relating to, floods or natural disasters or something. So I don't think it's a matter of new or old interpretation. I think the governor's office saw this provision in the statute. I think it was a reasonable provision, a reasonable position for them to take, that they had the authority to do what they did. I think it's the legislature's prerogative to retain the authority and to not have it granted to the executive branch. And so that's why I support the bill. But I don't fault the governors for their interpretation of an ambiguous statute. And that's why I asked if, early on, if Senator Limmer had any earlier citations that had prescribed in some way the way we ought to interpret this phrase. And he didn't have anything, because I don't think there has been any interpretation before. But that said, I did want to go back to one other thought, which was sort of the concept and the need for these orders in the first place. I mean, which is one reason I support the governor's efforts to try to get his arms around what we've been dealing with. There's a reason why this statute exists. It's because the legislature, as far back as 1951, recognized that the legislature, by design, institutionally and constitutionally, does not have the capacity to respond nimbly and quickly to changing circumstances in the occasion of an emergency. In this case, an invisible but deadly threat to the population of the state. I'll give you an example. We passed the marriage registration statute just last week, which extended the deadline until May 31st, I think it was, for the registrars to be able to take marriage licenses online. And that was, we passed it 65 to nothing. It was not a controversial bill in any way. The same version passed out of the House. Absolute consensus on it. And still, we couldn't even get that passed before the deadline had expired. Even though we had a session the day after this committee passed it, it was not brought up on that Thursday because it was apparently determined not to ask the legislature to declare an urgency. And it was waited until the following week. If that bill had a different version in the House, if it had required stakeholder consensus, if it had required negotiation between the executive branch and the Senate and the House and community stakeholders, if it had required more than one committee stop, if it had somehow gone to the floor and had to wait several days before it was taken up on the floor, and then have a floor debate, maybe a floor amendments, maybe it passes. And then if it's not the same version of the House, you got to worry about conference committee time and further negotiation until you can find some kind of consensus to pass everything the same, and then send it to the governor. Those are the kind of fraught issues that were confronting the governor and remedies that the governor would have to bring to the table to deal with the pandemic. And so we just can't move quickly. That's why the governor is given the executive authority to act quickly to protect the public. And they've been able then to use that quick and nimble flexibility to redeploy state employees to respond to the pandemic response needs relating to vaccination and testing. They've used that authority to build state inventory of critical care supplies to make sure hospitals and long-term care facilities had a place to turn during this crisis. You may agree or disagree with some of the moves that were made, but there were regulations that enabled businesses to open or reopen while employees and customers were hopefully kept safe. There was no cost school-age daycare that was provided so that children, parents, school districts would have the flexibility of dealing with distance learning or hybrid learning as well. There was flexibility for school district fund transfers, so they had a place to keep they could work out their own financial needs to make sure they could do what they needed to do. There were enhanced protections for veterans in the Minnesota veterans homes. There was a suspension of evictions as well that would protect people from being thrown out on the streets because they lost their jobs relating to the pandemic and couldn't pay their rent. There were increased protections for workers in potentially very unsafe working conditions and protecting them from retaliation for raising safety concerns. There were protections for Minnesotans against price gouging on essential goods and services and the garnishment of COVID-19 relief payments. And there was expanded access to Minnesotans for unemployment benefits and relief for their employers as well. All of that. Can you imagine if we tried to get the majority leader and the speaker and the governor all on the same page and all of these things, how long that would have taken to try to decide what to do? And then as scientific numbers change 2 weeks later, trying to dial up or dial back on the specifics of the regulations, the legislature could not possibly have done that. So it's been, I think the statute has worked as it was intended to work. But this narrow issue that came before us today, I think needed to be addressed for constitutional reasons and separation of powers reasons. And that's why I'm in support of this provision.
Thank you, Senator Latz. With all those decisions being made by the governor, it almost makes you wonder what the legislature is for. Senator Bruce Anderson, I see you have your hand up.
If I may, to that point, Mr. Chairman, the legislature was meeting after the initial shutdown. The legislature continued to meet last spring while the governor was making those decisions and didn't have any hearings on these issues. There are plenty of committees, whether formally constituted or not, that met well throughout all of the interim periods between special sessions. They couldn't take any formal action, but they certainly could well have met, debated, proposed legislation, had stakeholders testify, participated in drafting up legislation that could have been passed during those special sessions. The legislature, at least the Senate, did nothing. So I wasn't quite going to go as far as Senator Bingham did, but Senator Johnson, in terms of her language anyway, but Senator Johnson, since you brought the point, makes you wonder what the legislature exists for. The legislature handed off the authority to the governor by abdicating its responsibility to meet and confer and discuss those issues. In my judgment, my apologies to Senator Kiffmeyer, but I felt that those last points need to be laid on the table in response to what Mr. Chairman Johnson had to say.
I do see a response here. Thank you, Senator Latz, from Senator Bruce Anderson. Senator Anderson.
Thank you, Mr. Chair. Mine isn't specifically to what Senator Latz or Senator Bingham had to say. I'd like a clarification, because we talk about looking for a prescribed situation as it's designed or specified in law. It says prescribed. And I wonder if Mr. Backus could tell me what or if, when the governor calls out the Minnesota National Guard for situations that have taken place across the state, from flooding to natural disasters, is that considered an executive order, Mr. Backus?
Mr. Backus.
Mr. Chair and Senator Anderson, I'm not entirely sure if that's technically an executive order. I imagine it is, but it's something I'd have to look into, and it would be something that presumably under Chapter 12 or elsewhere he's been authorized to do, but I've not researched it specifically.
Okay, I'm just thinking about things that the governor does without having to go to the legislature to get permission to do these things, such as the executive order that we're talking about in regards to this legislation, Senate File 89. So I'm just, maybe in our next committee meeting, if you have opportunity to look that up, that would be great.
Thank you, Senator Anderson. Senator Limmer. Senator Limmer, you're on mute. Okay.
Thank you, Mr. Chairman. Well, the bill has created a great impetus for discussion on executive orders. And maybe there may be some time in the future that we can have a more expanded discussion of that. Just a quick historic reference. We've had other emergency order provisions in law prior to the one we're talking about. At that time, the executive order that we had did not recognize the creation of a health executive emergency while the legislature was in session. The governor could not call one while the legislature was in session. He could only be allowed to call one when the legislature was not in session. But it did recognize that once a governor did call it at that time, the legislature had to be called into special session within 3 days. And that was to include the legislature in whatever decisions had to be made in the near future. That has changed. A few years ago, I think almost during everyone's tenure in office, except for the newbies here, we all voted on the alterations to that. But it did satisfy a level of transparency by getting the representational branch of government, the voice of the public, in those discussions. We now have a streamlined version now, and I just think that the bill, Senate File 89, is a good way to clarify the role of executive action and whether or not the penalties require legislative statute writing. And I think Senate File 89 will satisfy that from this point forward. So having that said, Mr. Chairman, I would wish to move Senate File 89 be recommended to pass and move to where? The floor.
All right.
As amended, Mr. Chair.
Oh, Senator Ingebrigtsen.
As amended, Mr. Chair.
Oh, as amended, I'm sorry. Yes.
Thank you. So do I need a second for that?
No second.
Okay, no second. All right, so the motion is to send this to the floor, Senate File 89 as amended. All those in favor say aye.
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 All opposed? Motion passes. Senate File 89 has passed the committee and will be moved to the floor. Senator Limmer.
I have nothing more to say, Mr. Chairman.
All right.
I don't believe there's anything before the committee.
With nothing else before the committee.
Chairman?
Oh, Senator Latz.
I've got a question for Chairman Limmer unrelated to this bill, if I may.
Senator Limmer.
It has to do with, I'm sorry, it has to do with our future agenda. Mr. Chairman, this committee and a number of other committees passed a number of pandemic-related bills over the course of last spring that made adjustments in deadlines and made adjustments in procedures and processes that had expiration dates on them. Optimistic expiration dates, it turned out, because the health emergency has lasted longer than I think anyone anticipated from a medical standpoint. Several of those bills came through the Judiciary Committee. We already dealt with one. That was the virtual marriage license application bill. But we also passed provisions relating to harmless errors and wills, provisions relating to the running or tolling of statutory deadlines. That one has an expiration date on February 15th. The harmless error one, I think, has some March 13th. February 15th is also a deadline for that one. There's a judiciary bill on delayed submission of fingerprints for the BCA. I don't know that they still need that, but that authority expires March 1st. Electronic signature submission for certain documents expired back January 6th. There's a notary's appearance by video extension, which expires March 31st. I wonder if the chairman could give us some guidance as to his plans with regard to considering whether these deadlines should be allowed to expire or whether they need to be extended further for the same reasons that they were passed in the first place.
Senator Limmer.
Chairman, thank you, Mr. Chairman. Senator Latz, we should examine all of them to see if they're still pertinent at this time. However, I may want to remind you, we have a split committee now. And so many of the references you made would be focused on the Civil Law Committee and not this particular committee. If you'd like, we could put Ken Backus under the spotlight right now and have him define the differences between all of the grocery lists that you just read, or we can assume that he'll give us a division of duties, and we should review them. Thank you, Senator Latz, for bringing that to our attention.
Thank you, Mr. Chairman.
Yes.
I note I'd forgotten the split in the committee, and unfortunately we have Senator Matthews, Chair Matthews, on this committee as well. We would probably need input from Priya also, who would be the Senate counsel on the civil side of things. But some of these deadlines are coming up very, very quickly, and people need to plan. And I know there's at least one request for some clarification in language relating to tolling of deadlines. That even practitioners are wondering, they need some clarification so they know what it really means. What does the deadline actually mean to them? So I will let both chairs, I guess, know that I've already put in motion the drafting of bills to extend the deadlines for these. So that I had not heard of any of that being done anywhere else. And I figured we probably need to get a jump start on it because we would like to make decisions, I hope, before the deadlines expire. Would welcome further conversation with any members of either committee, but particularly the chairs, as to where they go from here. so that we can get them on agendas and have discussions of them and make some decisions before the deadlines pass, because that would create an even greater dislocation. We already kind of faced that question a little bit with regard to people applying for marriage licenses, and we had to be assured it was retroactive, so that people who applied remotely didn't find out that their marriages or the marriage license that were issued and remotely weren't valid after they got married. So I don't know, maybe Chairman Matthews can give us some idea of whether he's given some thought on these questions as well, since he's on board here.
Thank you, Senator Latz. And I will say that I do have some language drafted concerning the tolling of statutory deadlines for some judicial procedures. So maybe we can talk offline regarding that. Senator Matthews.
Thank you, Mr. Chair, and thank you, Senator Latz. Yes, we have been having discussions. Several weeks ago, staff brought the list of the deadlines and the things, as you mentioned, that are coming up here soon. I had thought that that we had tried getting some drafting underway, but now as I'm saying that, I'd have to double check to know for sure. But it is on our radar. We are trying to push, and hopefully we need them resolved sooner than the first one was here in January. So yes, we are aware of it, and we are trying to work logistically to get the bills ready for having those discussions.
So Mr. Chairman and Mr. Chairman and Mr. Chairman, maybe once we get jackets back from the revisers, we can circle back and try to get coordinated so we aren't duplicating efforts. It would be helpful on things like this if perhaps the minority caucuses could be notified what the plans are on some of these things. These were not partisan issues. They were purely good government issues that we all worked our way through as we needed to. And there shouldn't be, we've got enough demand on resources, and staff resources, always a concern not to have to duplicate efforts. I don't know where exactly my bills are in the revisers process, but I suggest whichever ones come out of the hopper first, we get them signed and dropped in, and find co-authors in the other body, and keep the ball rolling, and look forward to working with all of you to make that happen expeditiously.
Very good. Any further business before the committee? With that, we are adjourned. Thank you very much.
Thank you, members.